Hi everyone. Today I want to explain something very important about sibling contact in the UK, especially when some children are in long-term foster care and one sibling lives at home. This video covers the facts, the law, how social services often break that law, and what you can actually do about it. So here's the situation many families face. 2 or more siblings are placed into long-term foster care, while one sibling, often a half-sibling, lives at home with no social services involvement and a safe parent. Before foster care, these children were seeing each other weekly or even more frequently, maintaining strong connections. But the moment the local authority decides on long-term foster care, suddenly sibling contact gets cut down to once a month, or even as low as 4 times a year. And what social services often say is, because they are only half-siblings, they get less contact, implying a difference in their relationship status. Alternatively, they might state, "We are reducing contact for the children in care, so the half-sibling will also only see them a few times a year," applying a blanket rule. Families feel powerless in these situations, and it feels like the vital sibling bond is being systematically wiped out, causing significant emotional distress. Let's be clear about what the law actually says regarding sibling contact in the UK. Under the Children Act 1989, Section 34, the local authority has a duty, not an option, but a legal duty to promote and maintain reasonable contact between siblings. This means they are legally obligated to ensure siblings can continue to see each other regularly, fostering their relationship. The official UK guidance, called Care Planning, Placement and Case Review, further clarifies this position. It explicitly states that half-siblings are still siblings, and that sibling relationships are often the longest and most stable relationships a child will ever have. Importantly, the law does not say half-siblings get less contact, nor does it allow social services to rank siblings based on whether they share one parent or 2. They can only limit sibling contact if there is a specific, proven welfare reason, such as emotional distress, trauma triggers, or safeguarding concerns. Even then, they must show concrete evidence for these concerns, not just convenience, staffing issues, or internal policy. This is where things often go wrong in practice, leading to breaches of legal obligations. Instead of doing individual welfare assessments for each child, some local authorities simply impose blanket rules. Examples include, half-siblings only get 4 visits, or now that it's long-term foster care, we reduce everyone's contact. Another common, but illegal, excuse is, we don't have staff for weekly contact, citing resource limitations. All of these are illegal reasons, as they fail to consider the unique circumstances and welfare of each child. The Children Act requires an individual welfare decision for every child involved, ensuring their specific needs are met. They must explain why contact needs to be reduced, why monthly or weekly contact is not appropriate, and what harm would happen if the children saw each other more. Most of the time, they cannot provide this explanation because they don't have a valid one. Instead, they reduce contact because it's simply easier to manage. That is a clear breach of the law, and it goes against the children's fundamental human rights under Article 8, the right to family life. So here's what families can do when they encounter these unlawful practices. First, request the written welfare analysis. Ask the social worker or IRO, please provide the written assessment explaining why sibling contact has been reduced and how this meets the children's welfare needs. They are legally required to give this document, so insist on receiving it. Second, challenge it in the LAC review. Tell the independent reviewing officer that the law was not followed and that the decision is not evidence-based. Third, make a formal complaint. Demand a review of the sibling contact plan and use the specific words, breach of Section 34 Children Act 1989. This precise legal phrasing is crucial for highlighting the specific legal violation. Fourth, if they ignore you, go to the local government ombudsman. The ombudsman has repeatedly ruled against councils for restricting sibling contact without proper justification. Their rulings provide a powerful precedent and can force councils to reconsider their decisions. Finally, apply to court if needed. You can apply under the Children Act for a court order to restore sibling contact. Courts usually support this, especially when there is no safeguarding risk, prioritizing the child's right to family life. Sibling relationships should not be destroyed because of convenience or administrative ease. Half-siblings are still siblings, and their bond is just as important and deserving of protection. Social services are legally required to protect that bond, not limited without proper evidence and justification. If you need help writing letters, complaints, or applications, please comment below. You are not alone in this fight to protect your family's connections.